All right. Next case is Orange County School Board versus Washington. Got 5 minutes set for rebuttal. You want a different amount of time?
That would be great, Your Honor. Thank you.
Yes, sir.
May it please the Court, John Palmerini, Associate General Counsel for the Orange County School Board. We are here as a result of a denied motion to vacate an arbitration award. It's the school board's position that arbitrators have to decide the issues and submit it to them by the parties. They don't get to go searching in the record.
The issue submitted to him was whether there was just cause to fire Mr. Washington, right?
Yes, sir, it was.
And he decided it. You don't like the way he decided it, right? But what can we do about that?
Well, the issue is whether or not there was just cause under two documents, the collective bargaining agreement and the last chance agreement. As Your Honor knows after reading the submittals here, Mr. Washington was previously slated for termination in 2009, and the school district and Mr. Washington entered into a last chance agreement. That's an agreement that basically allows employees to save their jobs.
Was this collective bargaining agreement, did it require a written form of award?
Yes, it did.
Did the written award have to provide the reasoning?
Yes, it did.
It says that in the contract?
Yes, it does.
Have the reasoning in it?
Yes, it does. And the last chance agreement in this case said that if he did anything, hold on, let me find the notes. If the arbitrator finds that the employee recognizes that failure to abide by reasonable management directives will be cause for dismissal.
The arbitrator had misinterpreted the meaning of the contract. Do you have a claim there that he or she exceeded their powers?
Yes, I have a claim that they exceeded their powers. Under the Markowitz case that I cited out of the 3rd DCA, an arbitrator exceeds his powers when he decides a case that was not framed by the pleadings, tried by consent.
Did you see this Visiting Nurse Association case out of the Supreme Court, November 6, 2014? Did you look at that case?
To be honest, Your Honor, I have not.
November 6, 2014, Visiting Nurse Association versus Jupiter Medical Center. You haven't looked at that case?
I have not, Your Honor. I would be happy to supplemental brief it after today if the court so desires, but...
Well, it seems to say that a claim that an arbitrator exceeded his or her powers is a jurisdictional claim. You agree with that?
It is... I'm not quite sure if I agree with that from the standpoint of there's no doubt that the arbitrator had jurisdiction over this matter. Not only the collective bargaining agreement, but the last chance agreement gave him jurisdiction to decide this matter. But he had to decide the matter in the way that the documents dictated. And in this last chance agreement, the only thing he was empowered to do was to decide whether there was a failure to abide by a reasonable management directive. And if there was,
The arbitrator misinterpreted the contract. Mm-hmm. You think that you have a remedy in vacating the award?
Well, I understand the law that states that a misinterpretation of law is not a basis upon which to overturn. The reason why we believe this is in excess of his authority is that he made a finding.
Well, if the contract said, let's assume hypothetically the contract says that just cause for dismissal is defined as, and it lists two things.
Right.
Being drunk on duty,
Right.
being drunk at work, or gross insubordination.
Okay.
And you tee this case up for the arbitrator, and the arbitrator decides that gross insubordination means telling a subordinate that you'd rather not do something.
Okay.
A complete misinterpretation of the meaning of the contract. Is that do you have a remedy in vacating the award in that circumstance?
I believe in that hypothetical the answer is no, because that's merely a misinterpretation of the law. What happened?
Interpretation of the meaning of the contract.
Meaning of the contract. That's, yeah, misinterpreted.
That you would argue that because he had to use that definition, when he doesn't use that definition, he exceeds his authority.
I'm not sure that I'm arguing that in this case, Your Honor. What I'm arguing is he made the finding requisite in there. He said that this, Mr. Washington had a record of erratic and disruptive behavior, and then he went on to say,
Well, I'm not, you mean the requisite finding, you mean that's the same as saying that his conduct was the same as what he had committed before? That's the same?
yes, Your
The
Honor.
same finding?
Yes, Your Honor, it is, in our
Did he
opinion.
make a finding that he had engaged in the same conduct that he had engaged in before?
I believe he recognized that in 2009, he was given a 5-day suspension and given this last chance agreement because he engaged in insubordination, because in 2009, he said, I'm not moving from the work bay in which I'm employed. Now, you fast forward to
The last chance agreement said that if he engages in the same or similar conduct, right?
Yes.
That's essentially what it said. Did this arbitrator make a finding that he engaged in the same or similar conduct?
I don't know that he went out and expressly said that within his award. I'll be honest, I don't think that he expressly said that in his award.
Wouldn't he have to do that to support your argument factually? Wouldn't he have to make?
No, I believe that if you take the first sentence of that provision of the last chance agreement, where it says, the employee recognizes that a failure to abide by a reasonable management directive will be cause for dismissal. He found that this employee failed to follow reasonable instructions. So once he did that, he found that there was a failure to abide by a reasonable management directive. And once he found that, the last chance agreement was very clear. It says that will be cause for dismissal. So once he made that finding,
The arbitrator did not enforce the contract.
that's absolutely correct, Your Honor. He did not enforce
Why
it.
isn't that the same as my hypothetical? If the arbitrator looks at a definition and applies a definition that is different from the definition that's in the contract, something that he makes up, why isn't that the same as my hypothetical?
No, I see now I see a little bit better where you're going with that, Your Honor. If there's a clear definition in a contract and he doesn't apply that, then I think he has exceeded his authority in not applying.
Isn't that just a misinterpretation of the contract? I mean, we hear this kind of arguments all the time. The contract language is plain, and it can only mean one thing. The trial judge legally erred, and by misconstruing the contract. And your argument is the arbitrator basically erred by misconstruing the contract. I agree with you that the arbitrator erred by misconstruing the contract, and the decision was wrong. But I'm having a hard time translating that into exceeding his or her authority.
Here's where I think he is wrong, but I think here's where the excess of the authority comes into play, Your Honor. He got to deciding that termination wasn't appropriate in this case for two reasons. One, we didn't psychologically test the grievant before we fired him. Two, we didn't provide a notice of dismissal. Those two bases to justify not terminating this employee were never alleged in the grievance. They were never argued in the arbitration hearing. They were never argued in the post-hearing brief.
But it was postured to the arbitrator that, what we're asking you to decide is not just whether the last chance agreement was breached, but also whether it was just cause for termination in accordance with the collective bargaining agreement. And in essence, that seemed to broaden the scope for your arbitrator, who then took that and ran with it and concluded, as he concluded, that there was not just cause for termination, and that's within the scope of his authority as the arbitrator based on the collective bargaining agreement. Isn't that kind of where you're in a box based on how it was postured?
I don't believe so, Your Honor, and here's why. Because under our collective bargaining agreement, it's in Article 3 of our collective bargaining agreement, it requires the grievant, when stating a grievance, to cite the specific articles of the contract that have been violated and that are at issue in the case. In this instance, this grievant did not identify the psychological testing article as being violated. He did not cite the written notice article as being violated. As a matter of fact, the written grievance in the record at pages 295 and 296, every single citation of error in there is to the last chance agreement. So at the very least, under our contract, I understand Your Honor's question that whether or not there was just cause under both the CBA and the last chance agreement. That still doesn't negate the requirements to state a claim under specific sections of the contract. They still had to identify those sections. The first time the district ever knew that the psychological testing and the written notice of termination issues were at issue was when we saw the arbitration award. That did not give us any ability to address that before this case was decided. At the very least, due process requires that if an arbitrator is going to decide a case on some bases in the contract, that he has to give us a notice and opportunity to be heard on that.
What case are you relying on for that proposition?
That is the Talil Court versus Simonovich. And I believe that's out of the 4th DCA in 2012. And it says, agreements to arbitrate disputes under collective bargaining agreement does not preclude review by courts of procedural, due process, and jurisdictional issues. Thus, the failure of arbitrators to give notice and an opportunity to be heard is such conduct and misbehavior as will vitiate an award.
Well, I mean, what was the facts of that case? Is that the liquidated damages case?
Yes, I believe that's the one.
They got no notice of the hearing at all. I mean, do you have a case where some court has held that it is a violation of due process, it's a constitutional violation, for an arbitrator to allow the litigants to argue points that they didn't put in a grievance?
I don't have a case that specifically says that, Your Honor, but I would think that the very basic notions of due process would be that a court can't decide a case.
An arbitrator can essentially allow any kind of evidence in. He can overrule objections that it was, I wasn't on notices to this, and as long as the arbitrator, gives you a hearing, basically, I mean, you're kind of stuck with those rulings, aren't you?
You are, except if he decides issues that were not put in the pleadings. You are, unless.
You're arguing this as a due process issue, counsel, and I looked at your due process cases, and I don't see any due process case, that says that you have to specify in a grievance exactly which sections you're complaining about, or it's a due process violation for the arbitrator to decide that issue.
It may not be a due process issue when you put it in just those kind of plain terms, Your Honor.
It's a violation of the contract.
It's a violation of the contract, and it's also in excess of his authority as found in the...
An arbitrator can ignore a violation of the contract. An arbitrator can make a ruling that is in contravention of the contract, as long as the arbitrator has the authority to decide the ultimate issue, right?
They have the ability to be wrong. They do. And that is something we can't come here and challenge.
Well, that seems like what you're challenging here. I'm having a difficult time finding the bright line between an argument that an arbitrator exceeded his authority and simply an argument that the arbitrator was not only wrong, but he was 180 degrees wrong, and because he was so wrong, that's tantamount to exceeding his authority. Can you give me your best case that under a factually analogous argument that you're making here supports the proposition that an arbitrator has exceeded his authority?
Well, Your Honor, the first thing I would do is I would point you back to the Markowitz cases, the ones that if they decide an issue that's not raised.
You don't want to give me your best case?
No, and I'm getting there, Your Honor. I seriously, but I think that's part of my best cases.
This way, let me have you get there first, and then
Okay.
you can take some time and talk about whatever you want to talk about.
My apologies, Your Honor. I should have answered your case. The National Airlines, Inc. versus Metcalf case, that's the case where it says an arbitration award may be vacated when the award is so arbitrary and capricious as to deny due process.
Yeah.
That would be the best case that I would...
Award where the court did vacate the, is that a case where the court did vacate the award?
I'm not sure that it was. I'm sorry, Your Honor, the facts of these...
It's more helpful for me to for you to tell me about a case that's factually analogous where the award was vacated and the district court upheld the vacation of the award? If you got a case like that?
Well, the Markowitz case is where the district court upheld a vacation by a circuit court of an arbitration award. In that Markowitz case, what they did is they transformed a grievance for one party into a class action.
Yeah, but I mean, that's, the problem with that case is that it didn't have to do with the scope of the argument or anything else. It had to do with the fact that there was only one grievant who signed the grievance, and the arbitrator decided issues that related to other individuals. I mean, that's a pretty extreme case, right?
That is an extreme case, and I would posit that this case is the exact kind of extreme case.
Doesn't have any authority to decide issues pertaining to people that are not before him or her, right? That's a jurisdictional problem. That's a scope of authority problem, right?
I agree with you, the arbitrator can't decide cases for people not before him. I also believe that the cases say an arbitrator can't decide issues that are not before him. That's what this arbitrator did.
And which case do you have that you think?
That's the Schnurnacher case. That's the Florida Supreme Court case that says that an arbitrator goes beyond the authority granted by the parties in the operative documents, which, by the way, this arbitrator did with going beyond the authority in the last chance agreement.
The operative document included the CBA, though.
Operative document included the CBA, but once again, he still has to follow the mandates of the CBA that says he can only decide the issues as raised in the grievance by the parties. And I see
I have no problem in reaching the conclusion that he violated the contract. The difficult step that I'm having a difficult time finding that this arbitrator didn't have jurisdiction to decide this case.
I don't think you have to find that he didn't have jurisdiction to decide the case.
Seems to be what the Supreme Court has said in the November of 2014 case. That an arbitrator exceeded his or her powers is jurisdictional in nature, is what they said.
Well, not having seen the case, Your Honor, and I do apologize for that.
Disadvantage, but you're supposed to kind of keep abreast of authorities from a higher court. So let me save you some time for rebuttal, all right?
Thank you, Your Honor.
All right, sir. Yes, sir.
May it please the court, Your Honors. My name is Eric Shutoff, and I am counsel for the respondent, John Jr. Washington, in the case. This appearance at the 5th DCA marks the third time that I have had the pleasure of being on the other side arguing this case. And each time that I have argued this case, it has always started the same way, with Mr. Palmerini's remarks and going first and saving time for rebuttal. That's because from the very beginning at the arbitration, Orange County School Board bore the burden of proof. They bore the burden of proof in this case of proving the issue which was framed by both parties. They bore the burden of proving that there was just cause for the termination. They had to prove that to the arbitrator and did not successfully do that. They didn't carry their burden of proof. Before Circuit Judge Margaret Schreiber, they also carried the burden of proof, which is a very exceedingly difficult standard, has been defined in the law, of carrying the burden of proof, proving that the arbitrator went beyond his authority or some other very narrow exception to the rule.
Do you agree with your opposing counsel's statement that the CBA itself requires you to, as the grievant, to provide actual notice of what the bases for your claims are?
Well, the collective bargaining agreement does provide a process by which both parties put their whatever the discipline has been into play. I'm not sure that I would agree with the characterization that every explicit chapter and verse of exactly what's going to be argued in arbitration is set out at the beginning, because there are a number of steps in that grievance process. We don't start at arbitration. We start at mediation, actually letter discussions with supervisors. I think that lots of things emerge during that communication. So I would not agree that a person putting a grievance into play is expected to be literally to the tightest chapter and verse of what they will be arguing at an arbitration. They need to put the issue into play as what they're upset about. Here, Mr. Washington stated very clearly that he was upset about being terminated in the workplace.
I didn't read the part of the contract that talks about the grievance. What does it say about, what's got to be in the grievance? The written grievance. You have to file a written grievance.
You have to file a written
What does
grievance.
the contract say about what needs to be included in the written grievance?
There needs to be a statement of facts is collected. There needs to be, what action that the board has taken that you can test, you have to state that. But these are prepared by lay people, they're not typically prepared by lawyers. It's not, I'm not aware of any,
You say in the grievance.
excuse me?
Did your client say in the grievance?
That he was objecting to his termination, and that the characterization of his termination, and that he was asking reinstatement for his position, the remedy sought, basically wanted job.
Did he say that there was not just cause for the termination?
I do not know if he stated, I don't recollect, to be honest, Your Honor, whether he used the magic terms of just cause, but that is what every case is analyzed under, going back to enterprise wheel and car. It's the standard we've had since 1966, is there just cause to support the termination? And the collective bargaining agreement says termination will only be with just cause. So I would argue it has to be understood. I don't know whether the magic words were included. I did not prepare his original grievance, by the way. I came in at the arbitration part of the process.
To the arbitrator that, look, they improperly terminated your client because they didn't have any psychological testing performed, or that there was a failure to provide a notice of dismissal? Was that arguments made to the arbitrator?
In full candor to the court, it is not an argument that I heavily advanced or put. It wasn't the centerpiece. If you read the record, you'll see that.
Was it
But to be
made?
fully candid, it wasn't even referenced at all.
Well, I would not agree with that characterization, Your Honor, because the collective bargaining agreement was submitted as the first exhibit, and dead center, first issue on termination, the very part that it discusses termination, it discusses what the superintendent may do.
Just admit the document and say, it's somewhere in there that I was improperly terminated, just try to figure it out. I mean, you put forward that he was, for safety reasons, he was not doing whatever he was supposed to be doing, and that was all rejected factually and correctly, it seems like, by the arbitrator. But the question I think that we're asking is, you didn't argue it. I mean, Mr. Palmerini is saying, the first time we ever knew that's why we lost is when we got this piece of paper from the arbitrator saying, here's why you lose, Orange County School Board.
The arbitrator...
Is that
right,
accurate? Is that
right.
accurate?
Well, yes, with this caveat that the arbitrator is always entitled to be able to consider all evidence that's been made available to him. First of all, the collective bargaining agreement itself, but also the conduct during the arbitration itself. What Your Honors do not have the benefit of, and this is the reason that arbitrations are generally upheld and why we don't try to second guess or engage in fact-finding, Your Honor, is because the demeanor of my client during that whole arbitration was also evident to the arbitrator. It's not here. You're not hearing the inflections of his voice today. You're not seeing what happened during the frankly...
It's not really a fact. I mean, we're not saying that we're disputing the facts. I mean, it seems like what Mr. Palmerini is arguing is, if that's what you would have said what the issues were, and you put on evidence about it, and he put on evidence to counter it, and the arbitrator decide whatever he decided, that's the end of the story. But that's not his argument today.
The issue that we put in front of the arbitrator was whether the client was terminated for just cause. In considering the last clear chance agreement and the collective bargaining agreement, that was the issue put to the arbitrator, and he rendered a decision that was within those bounds.
What if there was postured to the arbitrator that the issue is whether the last clear chance agreement was violated, and that's what we want you to discuss? And the arbitrator says, okay, well, the CBA was violated, therefore termination is improper. Are
Well,
you having the same argument today?
It would be a different analysis, Your Honor, how it would come out. I agree. It would be a different, that distinction, if that was the only thing. But here's what I would also argue is you cannot consider the last clear chance agreement in a vacuum without the collective bargaining agreement. Let me give you an example. Nowhere in that agreement, I believe, if you read the last clear chance agreement, does it say who pays for the arbitration. It ends up being half by us, half by them. How does that get determined? Not from a last clear chance agreement. It comes from the collective bargaining agreement. Who decides that we strike one name from the list of arbitrators and then strike another to reach a name in the middle? That didn't come from a last clear chance agreement, but that is the process that was used. By the way, that's why the arbitrator was completely qualified to render this decision. He has a master's in industrial relations. He also is the head of graduate studies at Tampa College and was in labor management for 10 years with Bethlehem Steel as a management rep. How did we get to him? By striking one name, striking another. And how do we use that process? From the collective bargaining agreement. Mr. Palmerini never rang me up and said, we're working under a last clear chance agreement, and it doesn't say anything about who pays for the arbitrator. So, Eric, your client doesn't need to forward a check. No one would argue that the collective bargaining agreement is stricken or not part of the analysis. You can't take it in a vacuum. You can't separate out the collective bargaining agreement. And number one of the collective bargaining agreement, when it comes to discharge, when we're talking about termination, the very first thing discussed is the psychological evaluation. The arbitrator said to ignore that, they ignored that at their peril. He said, if you saw this guy the way I saw him.
I
Yeah.
understand that the CBA is the springboard to getting there. That's why you're there in the first place. If you both walked in and said, here's the sole issue we want you to decide, is whether this is in essence substantially similar grounds for why what happened in 2009, and you need to decide whether it is or not, and that's all we're asking you to do.
Yep.
If your arbitrator then issued the ruling that he has ruled that we're now talking about today, would that be exceeding his authority, or in your theory, it's once the CBA's in evidence, it's Katie barred the door as long as...
It could exceed his authority, and let me give you an example. The very first case that I ever argued in federal court, the Communications Workers of America versus AT&T Paradigm, in that case, both sides agreed to submit an issue to the arbitrator. They both agreed. They both said, you know what, we want you to decide how the severance benefits should have been awarded when several data mark facilities were closed in Pennsylvania. The arbitrator issued a ruling on that. We had the arbitration decision set aside, Your Honor. On what basis? Because the collective bargaining agreement, which gave the authority to the arbitrator to begin with, said that no decisions about severance pay can be made by anybody other than the company. So we were never even introduced any of that arbitration testimony. We went back to the collective bargaining agreement and said the arbitrator gets his source of authority from that document, and even if both sides submitted the issue to the arbitrator, if that issue was beyond his authority, the decision should be vacated. And we did vacate that, and it was upheld by the 11th Circuit Court of Appeals in a per curiam decision. So what I'm saying to you, Your Honor, is even if both sides agree on the issue to be framed, if it goes outside of the powers allowed in the collective bargaining agreement itself, it may indeed exceed the arbitrator's authority. So there are cases where that happens. That did not happen here because the procedure was followed of the collective bargaining agreement. The issue framed was whether there was just cause to support the termination. The arbitrator found that there was not, and he used three bases to render that decision about how the investigation was done, also the notice that my client received. So there are several issues on which he said that they had failed to do a proper impartial investigation and ruled that there was no just cause. He issued a ruling on what he was asked to do. Now, the fact that Mr. Palmerini doesn't agree, or I might not even agree, and even Your Honors, does not change the strict standard of review that we have. There's a number of cases cited in our brief involving county school commissions that have come to the 5th DCA where this court, have reiterated the fact that we don't retry, we don't go back and substitute our judgment for the arbitrators, even if there's an error of law, even if there's an error of fact. We simply look at whether he had the authority to do what he did. And that authority to decide this issue was given. By the way, I'll point out that the collective bargaining agreement also says that both sides agree to live with the decision of the arbitrator. Now, I recognize that legally, they can file an appeal, and that's what's got us to the 5th DACA, but they are violating the spirit of the agreement, which says that they will accept the arbitrator's decision as final. They have rejected it when a qualified circuit judge upheld that award, and they are challenging it now, the decision that was rendered by the arbitrator, so they're violating that.
Do that.
They have a right
It's
to...
a violation of the spirit, saying, well, if you lost, just live with it, you don't have a right to an appeal, therefore you're violating the spirit by appealing.
I understand, Your Honor. It just goes again to the standard of review and why it is such a narrow standard and why we don't second-guess the decisions of the arbitrator. So if he had truly exceeded the authority given him in the collective bargaining agreement, that might be a different case, but he took the issue that he was presented and was given. And he is entitled to consider all of the evidence, not only the agreement, but the transcript, what happened during that hearing. There is a reason that the psychological condition of my client became an issue. Now, I'd like to tell you that
Can an award be vague? Forget about whether it exceeded the powers. Under subparagraph 1D, you can vacate an award when the arbitrator otherwise conducts a hearing contrary to 682.06 so as to prejudice substantially the rights of a party. Aren't the rights of a party substantially prejudiced if the decision's based upon something that's not pled?
Here's what it is. First of all, what was pled, what was the issue to be cited was whether there was just cause to support determination, and if so, if not, what is the appropriate remedy? That is the issue that's framed. And
So how does the other side prepare for that, saying, okay, here's the big CBA, I guess it could be for anywhere from page 1 to 100 that there might be something in there, so we're going to have to guess to prepare for the arbitration hearing.
I think each side has to be very careful about what documents get in and don't get into the record, and that everything is to be to the purview of the arbitrator. The arbitrator can consider evidence that's presented, and as the court correctly pointed out, can even consider things like hearsay that would not be allowed in an ordinary court of law. The arbitrator can give it less weight, but can consider all kinds of things that would otherwise not be considered. There's always that issue, there's always a concern.
Saying that once the CBA comes in, the CBA, then however many pages it is, then they just need to be aware that there might be any reason set forth, even if it's not pled or argued or whatever, that could justify an award, and that's okay. That does not substantially prejudice their rights, even though they're not put on notice of it, other than the fact that there's a document, a big, broad document that says, here's the springboard for the authority to go forward with this case in the first place.
I appreciate that, Your Honor, but they also need to understand or be aware that in addition to the CBA, that if their cross-examination during the arbitration becomes so vigorous to the point that perhaps Mr. Washington is pressed to the breaking point and bits about his mental health become apparent to the arbitrator in ways that it's not apparent to you because there was a factual determination made then, I would caution either side against doing something that would perhaps make something like that emerge.
They're vigorously defending themselves or in the case, and they're asking questions. The arbitrator allows that. If your client has a visceral reaction to that, that should then put them on the notice in the course of the arbitration hearing that maybe there's a psychological component here that should be addressed for purposes of whether the determination was appropriate. How do they prepare for that?
I'll say this, Your Honor, is obviously that provision about psychological health is in the collective bargaining agreement for a reason. The very first thing when we talk termination is about what...
Isn't it clear that the arbitrator misread that? I mean, he read that to say, you have to do psychological testing before you terminate, basically. So the reason I think you didn't argue that is because that's absolutely not what the agreement says. It says they may do psychological testing, they may require. So it allows them to impose that requirement on someone like your client before they consider termination. It certainly doesn't require them to do it. So he misread it.
No.
Now you're saying that they're supposed to anticipate
No, Your Honor,
it's going to be misread in some way, and be prepared to argue that because you put the document in evidence?
let me be very clear. The arbitrator did not say that it requires it in all cases. In fact, the arbitration decision, very specifically, the arbitrator says the collective bargaining agreement says may, not shall. It doesn't say shall in the
They didn't do it, so...
They didn't do it.
Just cause. I mean,
The
that makes no
arbitrator
sense.
said they ignore their ability to do it, their may, at their peril in a case as of this. And Judge Schreiber of the Circuit Court pointed out, we don't have the public policy implications that have been raised by Mr. Palmerini. No one has said that this applies to all cases. They have said it only applies in this case with this particular claimant, that this should have been done, given what's there.
Don't raise that as an issue, you just say it comes up as a result of the arbitrator's award, and now you're saying, well, that's in there, that's on the first page, they should have been ready for that discussion, and so be it.
The arbitrator is entitled to consider a wide variety of evidence. No one has argued that this agreement or Mr. Washington's testimony was not properly offered, that there was some reason for striking it. The arbitrator simply gave more weight to those things than perhaps you or I would give to those. That's what occurred here. And the arbitrator said that Orange County ignored that provision at their peril in this particular case. Because, frankly, what he was saying, I mean, is you evaluate Mr. John Washington here, and you know what? This is different from perhaps the average bear than the average case, and I've seen it, and he made that decision, he made that election, which he had the power.
Of that, though. I mean,
Excuse me?
you could have said to the arbitrator, you know, we have here's my client, here's a psychological condition, this is really a critical factor vis-a-vis whether the termination was with just cause or not, and we're going to argue this, that they violated that provision of the CBA, and we're going to put on, whether it's hearsay or not, any kind of evidence, because it's certainly, they're free to listen to hearsay, and then the school board, or Orange County, has the right to put on whatever evidence they think they need to put on, so the arbitrator has a chance to decide based upon the issues that have been framed.
I agree, Your Honor, but up until that point, I had certainly never viewed my client in the context of the situation that emerged during the course of arbitration. Correct, but much like putting a witness on the stand and one does not know what that person exactly is going to say, and then a piece of evidence emerges, that doesn't prevent the arbitrator from being able to consider it and saying it goes into the just cause analysis. It doesn't prevent him from being able to do that. He's entitled to make his assessments of law and fact and call them as he sees them. He did not exceed his authorities to do that. And the standard of review is very clear that he has that power, and that is why the Circuit Court correctly ruled that no public policy was being implicated in this case.
All right, so you're over time, thank you.
Thank you.
All right, you got a little over 3 minutes left, sir.
Your Honor, Judge Torpey, you asked a question about what the CBA states about what has to be in a written grievance. I have it in front of me. It says, the written grievance shall be presented by the employee during a meeting with the administrator. The written grievance shall contain a specific date of the alleged violation, date of the Step 1 meeting, a concise statement of the facts upon which the grievance is based, a reference to the specific sections of the contract allegedly violated, an explanation as to how the employee believes each section was violated, and a suggested remedy by the employee. So they are specifically required to identify, in this case, to get the arbitrator to have jurisdiction, or to have the ability to rule on the issue, the psychological testing article, and they were supposed to cite the notice of dismissal article in order to give the arbitrator the ability to deal with those questions. They did not do that. And with respect to the district followed the collective bargaining agreement language at its peril. I agree with, I think, what the tenor of Judge Lawson's questions are. We should never be in peril for following the language of a contract and saying we don't have to do something if the words may. That is a completely discretionary act by the superintendent under this collective bargaining agreement. And quite frankly, what this arbitrator did is said, we should have done it. He converted that may to a shall. And under 447, 401 Florida statutes, he cannot change, modify, or alter a collective bargaining agreement provision, and that's what he's done in this case. With respect to the cross-examination I was the one who tried this arbitration case with Mr. Shattouf. Was my cross-examination vigorous? Yes. But as I pointed out, Mr. Shattouf, before the circuit court, said that the arbitrator made, and let me read from his argument to the circuit court. He says, because after taking testimony all day from various parties and hearing from my client, the arbitrator made an independent assessment that his mental state should have been evaluated. With all due respect to the arbitrator under Florida law, he doesn't have the ability to make an independent assessment of what should have been ruled and what should have been done. The only thing he has the ability to do is say, based upon the issues raised before me, did the district prove there was cause? And I would submit to this panel that under the last chance agreement that says a failure to follow a reasonable management directive is cause for dismissal. The fact that he found that there was a failure to follow reasonable instructions, that cause was
The
demonstrated.
arbitrator had issued a ruling that said, I find there was not just cause for dismissal, period. Is that award subject to being vacated?
If all he said was, I find there was not just cause, I'll be honest, probably not. Probably not, but he didn't do that in this case.
It's not, is because he had the power to decide that issue.
Correct, but he went one
Your
step.
fault is with his analysis.
My problem is he went one step beyond the authority he
He
was.
explained his reasoning, and his reasoning is fallacious, right? I mean,
Oh, I would certainly agree that his reasoning is fallacious, but he used provisions not at issue in the collective bargaining agreement to get to his
you answered my
conclusion.
question, and you're out of time. You're over time.
Thank you, Your
Thank
Honor.
you very much for your arguments, counsel. All right, the last